right to appeal. I said, here's my right to appeal. I said, you got to follow the petition. What do you follow the petition?
All right, everyone, pardon me. Thank you. We'll be getting the session started shortly. Please remember to silence your cell phones if you have not done so already. These sessions are recorded and live streamed. We are recording and live streaming right now for the first one. There will be a short break. There may not be a recess between them, but there will be a short break for us to bring the live stream and everything down. And then for the first session, for the first case, and bring the everything up for the second case. So there will be a short break there, but probably just 30 to 60 seconds. Judge Brooks, are you planning on asking for a specific amount of time for rebuttal? 5? Okay. All right, 5 minutes. I will go ahead and preset the time. Please let the panel know that, and we will get started shortly. Thank you. All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good afternoon. Welcome to the North Carolina Court of Appeals. I am Judge Allegra Collins. To my right is Judge Toby Hampson. To my left is Judge Jeff Carpenter. We thank our clerk, Mr. Gene Soar, and our Deputy Marshal Richard Remillard for being here today. We have 2 cases for oral argument today, State v. Jordan, number 21-91, and Alexander v. North Carolina State Board of Elections, number 21-77. Our first case is State v. Jordan. Counsel, would you like to reserve time for rebuttal?
Yes, about 5 minutes.
5 minutes for rebuttal. All right. Counselor, are you ready?
Yes, Your Honor.
You may proceed.
Thank you. May it please the court, my name is Christopher Brook, appearing for the defendant appellant Richard Jordan in this matter. Police officers entered a home occupied by Mr. Jordan without a warrant or any other basis in law on the evening of November 17th, 2017. The law and facts are plain. This was not a hot pursuit. The state's efforts to argue it was and to otherwise justify this search require the Court of Appeals to find facts, disregard the governing law, and on some occasions, do both. This court should reject the state's invitation and remand this case for a new trial. Your Honors, to briefly provide, well, Judge Hampson, I was just going to briefly provide a roadmap of the points that I'm going to hit here this afternoon. First, I want to just briefly go through sort of a factual and procedural background because the facts and the procedure are a little bit muddy in this instance. Second, I'm going to highlight why findings were necessary in denying this motion to suppress as a result of this motion to suppress hearing. And third, I want to highlight 3 of the principal shortcomings in the trial court's oral order and the state's arguments related to that oral order. Starting with the factual and procedural background. Police responded to something of a domestic dispute featuring a report of a woman, Miss Robertson, having stolen a car and gone to a house in Charlotte. Police proceeded to that house in question and they located the car that they were looking for in a parking lot behind a home. They did so around midnight. Shortly thereafter, a man, Mr. Thompson, approaches the car, sees the police, and returns to the house. He's led into that house by Mr. Jordan, the defendant appellant in this case. It's unsurprising because Mr. Jordan tells law enforcement later that evening that this is his uncle's home. Before they can close the door, Officer Williams, the first officer on the scene, puts himself in the doorway and has a brief interaction at the doorway with Mr. Thompson and Mr. Jordan. And at this point, he's joined by Officer Brito as well. They don't attempt to, in this interaction, arrest Mr. Thompson, crucially. Instead, after 15 seconds, Officer Williams enters the home, begins searching the home, does so without a warrant, does so without invitation. Officer Williams signals that he has identified what he believes to be probable cause.
Is there, we'll get to some questions later, but is there an issue of fact as to whether or not there was an invitation into the home or some form of invitation into the home?
It does, that initial interaction, based on the state's brief, no, there does not seem to be a dispute in regards to that. There is this reference in the trial court's oral order that is, Judge Hampson, somewhat ambiguous, and that this is meant has no slight to the trial court whatsoever. I hate seeing transcripts of myself speaking because it's run-on sentences and fragments as far as the eye can see. But there is a reference in that oral order to this brief interaction that happens in the doorway, and in the absence of anything else to the contrary, the door being closed, that perhaps the trial court says that this constituted, well, we'd rather have this conversation with you inside the house. There's no invitation whatsoever to come inside the house. My appreciation of the state's brief is that they do not argue that there was consent to enter given by Mr. Thompson or Mr. Jordan, and that is, I think, that has to be granted because there's just no evidence whatsoever of an invitation. Just rounding out the facts, Officer Williams enters around this point. He identifies what he regards as probable cause in the form of observing drugs and drug paraphernalia, and that probable cause that he identifies at that point serves as the basis for a subsequently obtained search warrant. To fully round out the circle factually here, ultimately Ms. Robertson, the woman who is the source of this original call about the car, is charged related to the car. Mr. Thompson is never charged related to the car. Mr. Jordan moved to suppress evidence seized after the warrantless entry. Officer Williams, who first appeared in the doorway, stood in the doorway, first entered the home and developed the probable cause I just referenced for obtaining the warrant, did not testify notably at this suppression hearing. So the trial court denies this order via an oral order holding that the warrantless entry was justified by hot pursuit. Two things about this oral order. First, this was not the plan. The trial court indicated it wished to enter a written order, but it ultimately did not do so. Second, though other facts and legal concepts are referenced in passing, hot pursuit alone bears the telltale indicia of a trial court holding, findings of fact and conclusions of law. And that's where I want to start by just, at the risk of stating the obvious, underlining that when it comes to hotly contested motions to suppress, like the current controversy, findings of fact and conclusions of law are necessary for meaningful, non-speculative appellate review. Findings are necessary when it comes to points that potentially affect the outcome of a suppression motion. And looking at this oral order, you see that hot pursuit bears that, that indicia, the tried and true formula of findings of fact and a conclusion of law. But
I want to jump quickly to standing.
sure.
And we've got a statement here, there was no time. Did the defendant indicate that he had any expectation of privacy?
Yes.
So if the defendant doesn't own the residence and he is not a lessor of the residence, does he have any expectation of privacy in this residence?
Yes, I want to make 2 points there. First, to the extent that that is a finding, what the trial court says is didn't indicate, quote, didn't want the officers to go, needed to get a warrant, that sort of thing. First, that's inaccurate. Officer Carson testifies, page 52 of the transcript, Mr. Jordan stated that we didn't have a warrant. He objected to a search occurring. And 1221 of Officer Brito's body-worn camera, Mr. Jordan says, quote, "You ain't got permission to go through the safe like that, though." So the trial court's assertion that there was, no objection to where the officers could or could not go, needed to get a warrant, those sorts of things is just not borne out. And that is, the first point that I would make is that there was an objection to a search without a warrant that occurred here, and that speaks to a reasonable expectation of privacy. Second, there are a myriad other facts that highlight and bear evidence consistent with a finding of standing. First, late night presence at this home. He's there, according to Ms. Robertson, when the leaseholder, Mr. Dietz, his uncle, was not present. He opened the door, permitted entry into the house for Mr. Thompson. On the body camera footage, he's drinking a beverage during the course of all of this. He has knowledge of associated businesses. He stood near, there's evidence that he stood near, had a key to, and according to Officer Brito, locked the safe that's sort of at the core of this dispute. The safe was out in the open. And then again, he refused consent and objected to the warrantless search. This highlights that he had permission to store items in this home. It also points out that which is what Taylor considered in a standing assessment in the North Carolina Supreme Court, it also signals that he had a degree of acceptance in the household, which is what this court in Barnes looked at in its standing inquiry, his late night presence without the leaseholder serving as the gatekeeper in regards to this home. But I also want to highlight, Judge Collins, another point. It is Mr. Jordan's burden to establish standing at the trial court. It's his burden at this court to highlight that there's evidence that is consistent with standing that is not resolved by the trial court. There are no findings that are actually valid findings in regards to standing, and that means that you have to remand.
Is there any conclusion that he had standing?
There seems to be a conclusion to the contrary. Again, to highlight here, the whole of the trial court's consideration of standing is one sentence in this 5-page oral order, and it is, "At no time did defendant indicate that he had any expectation of privacy, an interest in the property, didn't want the officers to go, needed to get a warrant," that sort of thing. That's the whole of the consideration. So I think we're speculating to even say that that's the basis for resolving this motion to suppress. This appears to just be a stray reference that's a conclusion of law without any valid findings of fact in support. So I think we're engaging in something of speculation, trying to tease out whether this played any role whatsoever. It's very plain looking at the oral order that hot pursuit is where the rubber meets the road, because again, we have those findings of fact. We have those conclusions of law.
So if the trial court hasn't resolved this issue, do we remand it for resolution of this issue?
But what Barnes did, where there was a very similar posture, a Fourth Amendment claim, where there was standing, again, decided by this court, there was a reversal of the conviction and a remand back to the trial court for a new trial. That's what this court did yesterday in Eddings, when there was the reversal of a motion to suppress, and there was a reversal of that conviction and remand back for the new trial.
So it's a new trial, it's not a new suppression hearing?
That's correct.
Or does it even go that far? I mean, my sense of your argument is that you believe there are questions of fact that needed to be resolved by the trial court, whether they were or not. There were substantial questions of fact that decided this matter.
Yes, Your Honor.
And is it not a requirement in those situations that there actually be a written suppression order containing written findings of fact, that a trial judge cannot just rely on oral findings of fact where there are contested factual issues?
Yes, there have to be, when there are contested factual issues, there have to be factual findings, and there have to be conclusions of law. And, again, when it comes to hot pursuit, there are factual findings, there are conclusions of law. The legal conclusion is wrong, and I'm going to come to that. That bears reversal.
But even still, is there not a requirement that when a trial court does resolve issues of fact, that they have to enter that written order resolving findings of fact, that they cannot rely on oral findings and a motion to suppress of contested issues of fact for us to...
Your Honor, it was my appreciation, and I stand to be corrected, that an oral order that made findings of fact and conclusions of law could suffice, that it's not absolutely required. This court has repeatedly said that the best practice here is to do what the trial court intended to do, which is enter a written order. But what is absolutely obligatory is when you have these conflicts about whether there was an objection to a search without a warrant, about Mr. Jordan's relationship to the safe that is at the core of this controversy, about his degree of connection to this home, those sorts of disputes where, at best for the state, there's conflicting evidence, those sorts of disputes have to be resolved by factual findings. And we talked a little bit about standing, but, I would highlight that in regards to the other things beyond hot pursuit, plain view, there's arguably perhaps a finding, but there's no conclusion of law that consent in any way justified that initial warrantless entry and search of the home. Same with consent. Perhaps a finding, but some of those findings are unsupported, and all of them lack a conclusion of law that they justified the warrantless entry and search of the home. We've talked a little bit about standing, but I want to return to it just very briefly because I think it's the first shortcoming in what the trial court does here. And I've highlighted what the trial court says in regards to standing. It's very short. It's not clear that that's the basis for the holding. I would argue to the contrary, but surely there are no factual findings in support of the bald conclusion that's in the order. But the standard is you need a possessory interest and a reasonable expectation of privacy. I talked about how Mr. Jordan objected to this search. But even if this finding was correct, that he had not signaled that he didn't have objections to officers going in certain places or searching without a warrant, the state grants that might be pertinent to the standing analysis, but verbalizing an expectation of privacy is not necessary to have an expectation of privacy. Courts have looked broader than what defendants say to law enforcement officers in regards to whether there is an expectation of privacy. There are no findings whatsoever as to whether Mr. Jordan opened the door, where Mr. Jordan was related to the safe, whether he had a key on his person, whether he locked the safe in the officer's presence, whether he stayed at the house without the leaseholder, whether he was spending the night at his uncle's house. There's evidence.
Is there any material conflict as to any of those particular facts?
Yeah, I believe that there is, Your Honor. There, I think, is evidence pointing in both directions about whether he was spending the night at his uncle's house. It's obviously late at night. He's having a beverage. But at the same time, he says that there, is nothing that he's keeping there. So I think that those things point in opposite directions. But again,
is that a material conflict, or is that just inferences that we could draw that go different ways?
I think that those are material conflicts. And also in regards to, his relationship to the safe, candidly, Mr. Jordan says things that point in both directions that merit sussing out by the trial court. He at some point says that he doesn't have a key and that he has no relationship to the safe, but then he grants that he has the key and he objects to this search. But there are three tranches, again, whether he objected to the search without a warrant, what his relationship to the safe was, his degree of connection to the home. All of these feature evidence that arguably points in both directions and is not resolved by the trial court. Turning to hot pursuit, which is the basis for the denial of this motion to suppress. The standard here is probable cause to arrest and hot pursuit to arrest. The trial court holding is that, quote, there's a reasonable, quote, justification to detain Mr. Thompson, the gentleman who walked out into the parking lot briefly, and hence follow him into the home without a warrant. In short, the trial court appears to substitute the Terry reasonable suspicion standard for Santana's probable cause for hot pursuit and to arrest standard. There are multiple problems with this approach. Though the state dismisses this as, and you'll have to forgive me if I mispronounce this, as a solecism, it is a vast diminution of the governing standard here in an area where the Supreme Court of the United States has drawn firm lines. Probable cause is very different than reasonable suspicion. And if sanctioned by this court, it would allow entry into the home on the slenderest of reeds. Furthermore, there are no facts, let alone findings, consistent with probable cause to arrest Mr. Thompson based on his interaction with the car. He's walking towards a car in a parking lot, he sees police, he goes back inside. That's not the basis for an arrest. It's not the basis for probable cause.
Wouldn't you concede that he was in fact in constructive possession of the car for at least a de minimis amount of time when he squared up to the door?
And he touches the car as well, Your Honor. Even if you grant that, Your Honor, and even if you granted that there was probable cause to arrest him based on that, which I don't think that there is, because obviously possession of a stolen vehicle entails knowledge that the vehicle is stolen. The body camera video makes very plain that the other people did not know that Ms. Robertson was in possession of a stolen vehicle. But let's think about this. There also needs to be some sort of the point that I'll make is even if you grant probable cause, you turn to the fact that there are no findings or facts that are consistent with hot pursuit. There's no effort to arrest upon this initial interaction with Mr. Thompson, despite ample opportunity to do so. Contrast that with the cases that the state references in their brief. Santana, hot pursuit case where Mom Santana is arrested immediately inside the vestibule of the home. Adams, a case where the defendant is arrested almost immediately just inside the front door. Officers Williams and Brito have an interaction with Mr. Thompson and make no effort to arrest him before entering the house, and make no effort to arrest him for very, very, very many minutes, and never attempt to arrest him based on the car.
Well, but that's one thing. We can talk about the time lapse, but is there actually a requirement of an attempted seizure prior to the hot pursuit beginning? Would it not be enough for a police officer to see a crime being committed right then, and without having the opportunity to even make the arrest, the suspect sees the police and immediately begins to flee before there's any attempted seizure even, right?
But I think that there would still, if you're going to enter a home, what the hot pursuit doctrine tells us is that you're entering the home to effectuate the arrest. And we don't see an entry into the home here in this instance by Officer Williams or any of the other officers who entered the home on that evening to effectuate an arrest. Officer Williams is entering that home to search that home, to find probable cause of drugs and drug paraphernalia. There is no effort ever during the course of that evening to arrest Mr. Thompson related to the car. So yeah, you can, there has to be some indication that you're actually attempting, that you're in hot pursuit going into a house to arrest, and there's just nothing factually or findings-wise consistent with that. But also, Judge Collins, back to your question, the Barnes case tells us that simply, engaging in a series of behaviors, none of which would provide the basis for an arrest, and then seeing the police and going away from the police does not provide probable cause. So I don't think that probable cause existed in this instance in regards to Mr. Thompson. Whether, the Terry standard would have been established as a different thing, but that's not the standard. But to Judge Hampson's point, there wasn't an effort to make an arrest, so it can't justify the entry into the home based on the hot pursuit doctrine. Final point that I will make, Your Honors, is in regards to consent. And the standard here is that courts have drawn a line between consent before a warrantless search. You don't need to get a warrant when you get consent on the front end. And after a warrantless search, where when you get consent after you've already unconstitutionally entered a home, you can't cure the taint of that unconstitutional entry by subsequently given consent. The trial court here, again, it's not entirely clear based on its oral nature, perhaps makes reference to the possibility of consent to the search from Thompson, Jordan, and the homeowner, as we discussed earlier, Judge Hampson. But he never makes a conclusion that any of these references to consent could justify the warrantless entry and would justify that warrantless entry. The state, as I mentioned, concedes that the trial court did not find that Thompson and Jordan consented to the officer's entry. Instead, it argues that the warrantless search could be ratified later by consent given by the leaseholder after incriminating evidence is observed. That's not an argument that the state made below, so I don't think it's an argument that's appropriate before the Court of Appeals. But more than that, that argument turns the case law on its head and violates at least two North Stars of the Fourth Amendment jurisprudence. First, Jardine. When it comes to the Fourth Amendment, the home is first among equals. Second, Payton. The Fourth Amendment has drawn a firm line at entrance to the house. Absent exigent circumstances, that threshold may not reasonably be crossed without a warrant. Little wonder, then, that the Fourth Circuit Court of Appeals has rejected exactly the argument that the state is putting forward in its brief related to consent. This argument that you can have an illegal search, find incriminating evidence on the basis of that illegal search, and then get consent that cures the taint of that illegal search is rejected by the Fourth Circuit in both Thomas and McCraw. But those searches didn't even involve the first among equals search of a home. They involved hotel room searches, evidence of exactly how far the state's argument in regards to consent misses the mark by. Later consent cannot cure the taint of an earlier illegal entry. So in closing, Your Honors, the trial court's conclusion that this was a hot pursuit is legally incorrect and must be reversed. The trial court's order otherwise does not provide a legal or factual justification for the warrantless entry to the home at issue here. Meaningful appellate review requires more than this oral order to justify the warrantless entry into a home. This court must reverse Mr. Jordan's convictions and remand this case for a new trial. Thank you.
May it please the court, my name is Joe Hyde. I represent the state in this matter. This case is before the court on the basis of the defendant's direct appeal from his conviction for his drug trafficking, possession of a firearm by a felon, and drug paraphernalia. There's a quotation that appears in just about every single one of these United States Supreme Court opinions that's cited in the briefs. The very core of the Fourth Amendment's guarantee is the right of a man to retreat into his own home and there be free from unreasonable government intrusion. To retreat into his own home. The evidence here showed, and the trial court essentially found, this was not defendant's home.
But that's not really a test. I mean, the Fourth Amendment doesn't require a title search to see who is the title owner of the real estate to determine whether you have standing. That's not the only test, right? I mean, the question is ultimately, did they have, reasonable expectation of privacy in that residence, in that place of dwelling?
A reasonable expectation of privacy. That's right, Judge Hampson. And what the case law has said, this is State v. McKinney, and also our North Carolina Supreme Court opinion, State v. Mlo, M-L-O, is that the burden is on the defendant to establish that he had a reasonable expectation of privacy in the premises.
And do you agree that we don't have sufficient findings to even be able to review the trial court's resolution of facts on this sort of fundamental standing issue?
I do not agree with that, Your Honor. The rule is that findings are required when the evidence is contested. When there's opposing evidence on a question of fact, it's the trial court's obligation to resolve that contest and make findings to resolve the inconsistency in the evidence, not the inconsistency in the party's arguments. Opposing counsel suggests in his reply brief that there was, I think, what he calls conflicting narratives here. I mean, obviously, the parties are going to make conflicting arguments as to whether this evidence supports a particular finding, but the fact is, defendant did not put on any evidence, either at the suppression hearing or at the trial. The evidence here was not conflicting. The evidence here was that when the officers entered, the defendant said, and I quote, "I don't have anything to do with anything that's in here. I don't live here. This has nothing to do with me." This isn't a suggestion where there's some ambiguity as to whether the defendant has a reasonable expectation of privacy or not. The defendant himself disclaimed any reasonable expectation of privacy when he said, "I don't have anything to do with anything that's in here." Now, opposing counsel suggested that there are a number of factors that I think he said imply or from which suggests that maybe there was a reasonable expectation of privacy here. I tried to write them down. He said defendant objected to the search or objected to the entry. If you look at the pages of the transcript that are cited for that assertion, there's no indication that the defendant objected. Now, it's true the defendant pointed out that the officers did not have a warrant. That's a statement of fact. At the time that the officers initially entered the house, they did not have a warrant. But again, this was not defendant's home.
Can I ask a question? If a defendant is actually the title owner of a home, okay, just for argument's sake, but he says to the police at the door, "I don't have anything to do with what's in here. This is not my home." Does he have standing to challenge that search?
That's an interesting question. So it is the defendant's house, but he claims not to have any.
That's right. He verbally says, "It's not mine," because the appearance of the officers is obviously
I mean, you can
rattled.
imagine a scenario where the defendant owns the home and is renting it to someone else. I think in that scenario, the renter of the home would have standing to challenge the search because the renter in that scenario would have a reasonable expectation of privacy.
What I'm
But
getting at is the defendant actually has a legal expectation of privacy in it, but he says, "It's not my house,"
Well,
hoping that they're going to let him off, right? So does he have an expectation of privacy if, in fact, the police walk through the door? He's the title owner
if
of
I
the house.
understand your hypothetical, I think you said the defendant would have a reasonable expectation of privacy in the residence based on his
His ownership.
ownership of the
So
house.
it's not necessarily what he says that is determinative?
I'm willing to grant that. It's not necessarily what he says. But the case law has consistently held that the burden is on the defendant to establish a reasonable expectation.
No, I understand. I just want to make sure that that's not, what he said at the door is not dispositive.
I think I would agree with that.
Okay.
The way that the structure is set up, where a defendant has to file a motion to suppress and file an affidavit along with that, the proposition that opposing counsel points out is correct. The burden is on the state to establish the lawfulness of the search. But the burden is initially on the defendant to show that he has that reasonable expectation of privacy. The way that's usually done is that in the motion to suppress, the affidavit says, "I own the house, I slept there, I keep property there," or what have you. And then the defendant can sit back and say nothing more. My pointing
Can't
out,
the defendant simply say, "I have a reasonable expectation of privacy," without going into the details of how that is? Isn't that what gets proved out at hearing?
right, I think in that scenario, it could be a contested issue at the hearing, right? In that scenario where a defendant asserts in the motion to suppress, "I have a reasonable expectation of privacy in this dwelling," the state then could contest that at the motion to suppress hearing and say, "Look, he claims this in the affidavit, but we don't have any evidence of that. He doesn't sleep there, his property's not there, he doesn't own the house." And in that scenario, I think you would have a case where the trial court would be required to make findings as to which of that conflicting evidence is to be believed. But that's certainly not what happened here. And it's relevant to point out that the motion to suppress, with all due respect to opposing counsel, he's kind of bouncing back and forth. He's challenging the search of the safe, and he's challenging the search of the home. The motion to suppress doesn't mention the word safe. The motion to suppress is not about the safe. The motion to suppress is about the entry and the search of the home, and it never says that the defendant owns the home. The first thing opposing counsel said, police officers entered a house occupied by the defendant. Occupied by the defendant. He lists a number of factors that are apparently indicative of, or suggestive, he says, of reasonable expectation of privacy. The defendant objected. The transcript does not reflect that the defendant objected to this search in any way. He says he was drinking a beverage. I'm not sure what relevance that has. I'm not aware of any case that says that's relevant to the question of standing. He said his knowledge of the business. I'm not sure whether he means knowledge of the drug trafficking business. It is apparent that defendant did have some knowledge of the drug trafficking business because the officer said he pocketed the key to the safe, and it was in the safe that the drugs and the firearm were found. But then the police officers went and got a warrant before they searched the safe. It's not the search of the safe that was the object of this motion to suppress. It was the entry of a home that did not belong to the defendant and that the defendant had no reasonable expectation of privacy in.
And does it matter that this affidavit says that the residence was occupied by Mr. Jordan? Does that support your argument?
It absolutely does, Your Honor. If this was a case where the defendant had a reasonable expectation of privacy, it would seem reasonable for the defendant to have alleged more than just he occupied the premises. The United States Supreme Court has said again and again, mere occupancy does not establish a reasonable expectation of privacy. It's not enough that the defendant was there when the officers came in. It's not enough that he had a beverage in his hand. It's true, there's evidence that he was there at night, but that alone is not sufficient to establish his standing to contest this search.
So could we look at the totality of the circumstances here? Occupancy plus beverage plus key to safe. Is there a totality of circumstances test for standing?
I can't cite you a case that puts it in terms of the totality of the circumstances. I think in this scenario, there was no conflicting evidence. All of the evidence suggests that the defendant had no reasonable expectation of privacy, and that's precisely what the trial court concluded. There was no time, at no time did the defendant indicate that he had any kind of expectation of privacy and interest in the property.
But is that sort of a difference between, what we call findings of evidentiary fact, right, and findings of ultimate fact, which are like, that ultimately support the conclusions of law. You can find evidentiary facts, this happened, this happened, this happened. The ultimate fact is sort of what did those facts, what's the bottom line inference of those facts? And that seems to be like, even if we have these evidentiary facts, we don't necessarily figure out what the ultimate fact is that then leads to the conclusion that there's no reasonable expectation of privacy.
There's no...
How do all these facts come together, evidentiary facts come together to create, what is the ultimate fact that says this person doesn't have an expectation of privacy?
I'm not aware of any case that identifies the single criteria. I think the indication is if you have a practice of sleeping in the premises, it's understood that you have a reasonable expectation of privacy there. But again, there was no conflicting evidence in this case. The fact that the defendant was there at night, the fact that he was in proximity to the safe, there was one other item that defense counsel mentioned at trial. Those things are not contested. He was there at night. He was seen in proximity to the safe. That's not the point.
Is there any evidence he was not an invitee?
Is there any evidence he was not an invitee?
That he was not an invitee, that he was not trespassing in the house.
He apparently was not trespassing. All the indications are he was there with the consent of the homeowner or the lessor. But again, that's not the test. The question is whether he had a reasonable expectation of privacy in this place.
So it's the state's position, if I invite a guest into my house, a police officer may simply just follow them right through the door.
In that scenario, you, the homeowner, would have the right to contest the search, but the person that you invited into your home would not, because it's not enough for your visitor just to be there. Now, if you invited that person into the house to sleep there for a week, I think the situation would be different. But it's true. It sounds a little bizarre to say, well, that means the officer can just waltz right in. That's not really what I'm saying. The homeowner in that case certainly would have the right to challenge that search. And if they tried to pin the drugs on you, then you would have a basis to say the officer made an invalid entry. But your visitor, who came in with drugs in his pocket and put them on your table, he's not in a similar situation. He doesn't have a reasonable expectation of privacy in your home absent some other indication that he sleeps there, that he spends time there regularly, something. And in that case, that person would not have standing to contest that search.
When does the reasonable expectation of privacy have to be established? It appears from the findings, what there are of them, from the trial court, that the trial court would have expected the defendant in this case to establish that he had an expectation of privacy as they're walking in the door. Wait a minute, this is my house. When does that have to be established? Does that have to be established on the spot? Or is it later that we're looking back to see what happened and the mere assertion that he was an occupant in his affidavit feeds that?
I think that it would be sufficient if that were established at the motion to suppress. I don't think it's necessary that the defendant say anything at the scene.
That's what I believe to be one of the findings of the trial court, that he didn't say anything about having an expectation of privacy at the time of the search.
Sure. But, okay, yeah, I understand that. The question of whether the defendant has a reasonable expectation of privacy, I think, is adjudicated and determined at the motion to suppress hearing. There's no obligation on a defendant to make an assertion to the police officer at the time that the officer is coming in.
And that's sort of part of the tension in this case too, right? Is that in the theory of this warrantless search is hot pursuit, or at least one of the theories. So it's unlikely that a defendant, I guess it could be the gingerbread man, I guess, but it's unlikely the defendant's going to claim a reasonable expectation of privacy while they're fleeing the police, right?
Sure, absolutely. I would like to touch briefly on the fact that the trial court's order here can be upheld on 4 different bases. It's not just exigent circumstances that supports the order here. There is, in addition to that, the fact that the homeowner gave consent and the fact that the search of the safe was conducted pursuant to a warrant. Now, it's certainly true, as opposing counsel suggests, that consent might be rendered invalid, a warrant might be found insufficient, where either of those were obtained as the result of a prior unconstitutional search or seizure. But the defendant at trial, neither at trial nor on appeal, has made the argument that the consent was invalid or that the warrant was somehow tainted. There was no argument below. In fact, counsel acknowledged at the trial court that he was not challenging the warrant. That's relevant because the evidence that was introduced against this defendant was found in the safe, and the safe was searched pursuant to a warrant. So even if this court were to find somehow, contrary to the evidence, the defendant had standing to challenge this search, the search of the safe that produced the evidence against him was conducted pursuant to a warrant, and he's never shown that that warrant is invalid. I would like to turn quickly to the exigent circumstances doctrine. I don't think there's any dispute about what the rule is. Police officer has to have probable cause to arrest and has to be in hot pursuit of a suspect. The other possibility is that there's probable cause to arrest and there's a potential for the immediate destruction of evidence. Both of those criteria are satisfied here. Judge Collins, as you pointed out, the fact that Marcel Thompson squared up on the car that the police officers were investigating as a stolen vehicle certainly gave them probable cause to arrest Mr. Thompson for possession of a stolen vehicle, which is a felony. The fact that it's a felony is important because this is rather curious. The United States Supreme Court decided a case while this case was pending called Lang v. California. And what Lang v. California held is the pursuit of a fleeing misdemeanor suspect does not categorically qualify as an exigent circumstance. I would just point out that case doesn't particularly bear on here because possession of a stolen vehicle is a felony. And the United States Supreme Court has held that pursuit of a fleeing felon, in addition to probable cause to arrest, does constitute an exigent circumstance for a warrantless entry of the home.
Just so that I'm clear, the state's argument that the destruction of evidence was that the keys to the car could be flushed down the toilet?
It's not so much that they could be flushed down the toilet, Your Honor, as that they could be dispossessed from the person that the state is interested in prosecuting for possession of the car.
But the car's not going to go anywhere.
The car's not going to go anywhere. Absolutely not. But again, the car can't be prosecuted. It's the person who's in alleged possession of the stolen vehicle, in this case, Mr. Thompson, and it would certainly be beneficial to the state's case if the officers were to catch
Just
Mr.
the
Thompson.
evidence of the possession where you're linking the keys to the car.
Precisely.
Okay.
And the fact that Mr. Thompson doesn't have knowledge that the car is stolen or not, I think the case law is pretty clear. Knowledge is something that has to be submitted to the jury because you're never going to have direct evidence of knowledge. If opposing counsel wants the police to have direct evidence in every case that the person is not just committing a crime, but knows that what they're doing is a crime, it would be impossible for the state to prosecute 99% of the crimes that it does. The question of knowledge is one for the jury. What you have here is a situation where Thompson squares up on the car. He might have the keys in his pocket, he might not, but it would certainly be beneficial for the state's case for the officers to catch him with those keys before he has, I'm not saying he's going to flush them down the toilet, before he puts them on the table, before he throws them out the window, before he hands them to somebody else in the residence, and they all say, I don't know what the keys are, I don't know.
And so just so that I'm clear on the standard, beneficial to the state, that seems to be a fairly low bar to go in for a warrantless search, that evidence would be beneficial to the state.
What I'm suggesting is that the destruction of evidence constitutes an exigent circumstance. The destruction of evidence here would be the dispossession of the keys. And because the dispossession of the keys is potentially imminent, that, alongside the probable cause to arrest, constitutes an exigent circumstance.
Do we have any cases that sort of make that a little bit more tenuous link? We usually talk about flushing drugs down the toilet so that the actual evidence of the crime is gone. Do we have anything that gets us to a link?
I'm not aware of a case involving car keys. I think the cases that are cited in the state's brief are Adams and Stover. Stover is the case that deals with the destruction of evidence, but I think it was drugs in that scenario.
Right, okay.
Did the trial court make any oral findings regarding, on specifically this issue, that the officers were concerned about the destruction of evidence, or?
I don't believe it did, Your Honor. It said there's also an argument of a circumstance where the defendant was fleeing. Officers had reasonable, this is the language that opposing counsel objects to, reasonable justification to detain Mr. Thompson. There would have been a heightened concern for potential loss of evidence or something nefarious afoot. So there is the concern about the potential loss of evidence. But in terms of the evidence being the possession of the keys, I can't point you to a specific case, no.
The evidence of that Mr. Thompson may have had the keys is simply that he walked up and squared up to the car. That's the evidence that he may have had the keys.
Well, in addition to the fact that the police were there investigating this stolen car, I mean, it's not just the fact, sure, that's sort of the crux of the matter here, is that it was Mr. Thompson is the person that they were pursuing when they entered the house.
Could they just have easily assumed that since Mr. Thompson was there and they were investigating the stolen car, that maybe he had drugs in his pocket too that would justify that? I mean, that's a big leap that we're making, that the gentleman walked out to the car, so therefore he's got to be the owner, he's the one that stole it, he's got to have the keys in his pocket. And that's kind of the assumption that the officers made here, isn't it?
Maybe I'm not understanding you. You said something about drugs? I don't think it would have
That was drugs aren't involved in this. That was a hypothetical.
Okay.
But if we're making assumptions,
Sure.
are we free to assume whatever we'd like
No,
to support
absolutely not. No.
to support an arrest later?
No.
And
There
that's how did they get to the point of assuming that this guy had anything to do with the car, other than the fact that he just happened to walk up to it and square up to it, or look at it?
That's it, Your Honor. That's it. You have a allegedly stolen car in the vehicle. You see the person coming out of the house and squaring up on the vehicle. And in addition to that, after he saw the police, he returned quickly to the residence and said, it's the police. I mean, I think you see in his flight there some evidence of guilt.
Flight generally in our case law is constituted by fleeing in a vehicle or running on foot. This was, he walked down and he walked back, although the adjective used was hastily, I believe.
Right. And what Adams says, quoting, I think, a U.S. Supreme Court opinion, is the fact that this pursuit was over almost as soon as it begun doesn't make it any less hot pursuit. The fact that he squared up on that vehicle and then saw the police and ran.
Hot pursuit, as you pointed out earlier, requires probable cause, correct?
Well, both, what we have here, exigencies in any case, you have to have probable cause to arrest.
And that's, I'm trying to get back to that point. The probable cause here is that this gentleman walked down to the car, squared up to the car, and then turned and hastily walked away. That's probable cause.
To believe that he's in
Prob-
possession?
A crime was probably committed, and that guy probably committed it.
Yes, Your Honor.
Okay.
Yes. I would add to that the fact that there is some indication even before they encounter that suspect that the car is stolen. So it's not just him, but the additional circumstances. But ultimately, yes, I would agree with that. I'll touch on briefly the suggestion that there are not sufficient findings for this court to uphold the order on the basis of standing. As I pointed out, the test is not whether the case is hotly contested. The case is not whether clever attorneys can come up with an argument on the basis of the uncontested evidence. The question for whether there must be findings is whether there was actually conflicting evidence about whether this defendant had a reasonable expectation of privacy. There was no conflicting evidence here. These questions that opposing counsel points out, whether the defendant objected, there's no indication in the transcript that the defendant objected. His relationship to the safe is irrelevant because the motion to suppress was not challenging the search of the safe, it was challenging the entry of the home. And the degree of connection to the home, defendant himself told the officers he had no connection to the home. The motion to suppress did not supplement or add to that assertion with any additional indication that he had a possessory interest in the home, or owned the home, or slept there, or had any reasonable expectation of privacy.
So we have this order, oral order. Do we only need findings of fact on specific issues that have conflicting evidence?
Yes.
And every other, we can therefore fill in with whatever facts are not conflicting in the rest of the transcript and the rest of the record?
That's right.
Okay.
That's absolutely right.
Right.
I think the case is Bartlett, is that the case? Where the evidence is not conflicting, our Supreme Court has said it is assumed that the trial court made findings on the basis of that unconflicting evidence that support the denial of the motion to suppress.
But usually we've either got an order with no findings or an order with findings, but it seems like we're trying to put together a hybrid order where you've got findings on conflicting things and then we're free to sort of fill in the rest of the findings where things aren't conflicted, and I haven't really seen a case like that.
Well, with all due respect, Your Honor, I don't agree that there was conflicting evidence here. All of the evidence was presented by the state. The officers testified consistently. There was no evidence presented by the defendant. There was no evidence that he owned the house, that he slept there, that he had any reasonable expectation of privacy. So if we treat this order, that admittedly includes findings and conclusions, if we treat that order as one based on the evidence presented, an order in which the trial court resolved this question on the basis of defendant's lack of standing, there need be no additional findings because there was no conflicting evidence. And to the extent this court finds that it's necessary to remand for the trial court to say again what it already said, the defendant had no reasonable expectation of privacy, I would point this court to Johnson, which is, I think, the last case cited in defendant's principal brief and cited again in his reply brief. In Johnson, what our Supreme Court did was remand for an additional voir dire on the question of the admissibility of that evidence. This is page 589. The lack of sufficient findings in this case, as well as the lack of evidence in the transcript, compels us to remand the case for a new voir dire proceedings, consistent with this opinion. So the assertion would be the evidence was not conflicting here. No findings were necessary. To the extent there were a necessity of findings, the trial court found that defendant had no reasonable expectation of privacy. But if this court is concerned about what defendant was drinking or his knowledge of the drug business, it's certainly free to remand to the trial court to make additional findings that defendant had no reasonable expectation of privacy. It certainly does not warrant overturning the conviction on the basis that that the trial court didn't put its findings in the proper terminology. Unless the panel has any additional questions, the state would respectfully request that this court find no error at trial.
Thank you. Counsel?
Very, very briefly, Your Honors. I want to start with this destruction of the keys point. As I understand the state's argument, the theory related to probable cause is that he had the keys to this car and he had constructive possession of the car by squaring up, as you were highlighting, Judge Carpenter, and touching the car. But as the state acknowledges, you need to have probable cause plus an exigency. And the exigency they're arguing here is destruction of evidence. The probable cause theory that they have destroys any argument as to exigency. Because if the theory is on probable cause is he has possession of a stolen vehicle, he has keys to that stolen vehicle, they follow him and detain him in the doorway and are with him for the entire time, more than an hour of the body camera footage. He never has an opportunity to secret the keys away anywhere. So to the extent that the state's argument in regards to probable cause is followable, it destroys the argument in regards to exigency because they detained Mr. Thompson and had control over whether he was going to be, operating some sort of grinder to grind up keys or flushing keys down a toilet or putting them in a corner somewhere. Second, in regards to the standing point, I'll just highlight that the state is proposing a formalistic magic words inquiry that is just not supported by the case law. The case law actually focuses on things like permission to store items, degree of acceptance in the household. And here, drinking a beverage in somebody's house and having knowledge that there is a nail salon that's next door and a massage parlor which is next door, which is what's reflected by the body camera footage, reflects that he has a real, knowledge of the home, degree of acceptance of the home, not that this is just a business transaction where he is not familiar with the home. Also, apparently, to the magic words inquiry, Judge Carpenter, if he'd said, I have a reasonable expectation of privacy, if he'd just been sort of a capable 1L, instead of saying, you ain't got permission to go through the safe like that, the outcome would be different here in regards to whether they're standing. The case law doesn't support that sort of hyper-formalistic view of what is necessary to establish standing.
So I want to ask a quick question. When we go back to the fact the defendant said, I don't have anything to do with that stuff in there, it's not mine. I'm not saying the correct words, but that was his essence. If the police then go in and conduct a warrant thinking reasonably that he has no reasonable expectation of privacy, is there some sort of mistake that we forgive the police and they didn't need a warrant?
Well, what he says is, I don't live over here, I ain't got nothing in my name. He then also says, I'm here visiting my uncle. So there is evidence that's pointing in different directions that, again, findings would be helpful in regards to. But the search warrant is for both the house and the safe. And he is very clear that he has a possessory interest and a reasonable expectation of privacy in the safe. For heaven's sake, it's a safe. A safe is a pretty good way to signal that you have a possessory interest in its contents. A safe is a pretty good way to signal that you have a subjective expectation of privacy in its contents. If society isn't willing to recognize that you have an objective expectation of privacy in a safe inside of your uncle's house late at night that you refuse consent to search, then where is an objective expectation of privacy? Finally, and I know I'm very short on time, Your Honors, but I want to run through that there is conflicting evidence here that needed to be resolved by the trial court. I count 3 different views, and Judge Hampson, this goes to your point about ultimate findings, about what Mr. Jordan said and about what that meant. The trial court says that it meant nothing, that he did not signal any disquiet about the search or that was occurring. The state says that it doesn't constitute an objection, but he said again, you ain't got permission to go through the safe. That certainly lends itself to being construed as an objection, and in the totality of the circumstances needs to be assessed, and a finding needs to be made about what that means, and the ultimate finding is not present here. And again, I count 4 different views of the relationship to the safe, Body-worn camera is not clear about this. You might see him with the keys. It's unclear what he's doing. Officers say he had keys. He locked the safe. He objected to search of the safe. The state focuses on his, disclaimer, his self-interested disclaimer, which is ambiguous and is not determinative at the case law. But the trial court never considered it. Those sorts of things needed to be resolved by the trial court. We would again urge this court to reverse and remand for a new trial. Thank you.
Thank you. Thank you both. This case is submitted. We are not going to adjourn, but we will recess briefly to allow the safe entry and exit of attorneys.